You may be seated.
So we have 16 here. We have a question from the jurors that really not about the evidence, but more a procedural question I'm going to address before we bring them in. Did you read the question? They need to know what their numbers are. You want to?
I wrote it on your sheet of paper.
The question that the jury submitted was, can we get a clarification on our, quote, jury number? There have never been any anything confirmed. As you all know, we're trying to protect the identity of the jurors, so I have a list of the jurors' names and their numbers. So I'm going to have our clerk step back and tell them what their numbers are. If they need to write them on their hand or whatever they need to do to help them remember, then we'll allow them to do that. Because at the conclusion of my instructions, then we will select randomly the 4 who are to be alternates, and they will be separated from the 12 that will be deciding the case at this point. So. Officer Howell, when they come in, I want you to hand them each one of those copies.
Yes, sir.
I assume everyone at the council's table has a copy of the charge, correct? General Sagi, does your copy of the charge have page numbers on it?
Yes, Your Honor.
Okay, I just wanted to make sure. All right, ladies and gentlemen, this will be the final charge of the court. I think everyone have their own copy now to follow along. Ladies and gentlemen of the jury, the defendant, Stephen Joshua Wiggins, is charged in count 1 in the indictment, in this case, with the crime of false report. In count 2 in the indictment, the defendant is charged with the crime of premeditated first-degree murder. Necessarily included within a charge of premeditated first-degree murder is the lesser included offense of second-degree murder. In count 3 in the indictment, the defendant is charged with the crime of first-degree murder in the perpetration of a felony crime. Necessarily included within a charge of first-degree murder in the perpetration of a felony crime is the lesser included offense of second-degree murder. In count 4 in the indictment, the defendant is charged with the crime of theft of property. Sergeant Daniel Scott Baker's patrol vehicle number 500, a Ford Explorer police cruiser owned by the Dickson County Sheriff's Office. Necessarily included within this charge of theft of property is the lesser included offense of unauthorized use of a vehicle. In count 5 in the indictment, the defendant is charged with the crime of theft of property. A Glock 17 handgun and a Glock 33 handgun possessed or owned by Sergeant Daniel Scott Baker. In count 6 and 7 in the indictment, the defendant is charged with the crime of criminal impersonation of a law enforcement officer. In count 8 in the indictment, the defendant is charged with the crime of tampering with evidence. In count 9 in the indictment, the defendant is also charged with the crime of arson of personal property. In count 10 in the indictment, the defendant is charged with the crime of abuse of a corpse. The defendant pleads not guilty to each and every offense contained within the indictment and to each count thereof. The evidence and arguments in this case have been completed, and it is my duty now to instruct you as to the law. The law applicable to this case is stated in these instructions, and it is your duty to carefully consider all of them. The order in which these instructions are given is no indication of their relative importance. You should not single out one or more of them to the exclusion of another or others, but you should consider each one in the light of and in harmony with the others. The law presumes that the defendant is innocent of the charges against him. This presumption remains with the defendant throughout every stage of the trial, and it is not overcome unless from all of the evidence in the case you are convinced beyond a reasonable doubt that the defendant is guilty. Reasonable doubt is that doubt created by an investigation of all of the proof in the case and an inability after such investigation to let the mind rest easily as to the certainty of guilt. Absolute certainty of guilt is not demanded by the law to convict of any criminal charge, but moral certainty is required, and this certainty is required as to every element of the proof necessary to constitute the offense. The state has the burden of proving the guilt of the defendant beyond a reasonable doubt, and this burden never shifts but remains on the state throughout the trial of the case. A defendant is not required to prove his innocence. The state must have proven beyond a reasonable doubt all of the elements of the crime charged, that it was committed before the finding and returning of the indictment in this case. The state must prove beyond a reasonable doubt the culpable mental state of the accused. Culpable mental state means that the state of mind of the accused at the time of the offenses. This means that you must consider all of the evidence to determine the state of mind of the accused at the time of the commission of the offense. The state of mind of the offense as outlined in these instructions. The indictment in this case is a formal written accusation charging the defendant with these crimes. It is not evidence against the defendant and does not create any inference of guilt. The burden is upon the state to prove by a preponderance of evidence that this offense was committed in Dickson County, Tennessee. Venue of the offense lies in the county where the offense was commenced or consummated. Proof by a preponderance of the evidence means that the greater weight of the evidence must be in support of the state's contention. If you find that the state has failed to prove by a preponderance of the evidence that this offense was commenced or consummated in Dickson County, Tennessee, then you must return a verdict of not guilty. Count 1. As heretofore stated in count 1 in the indictment, the defendant is charged with false report. Any person who makes a false statement to a law enforcement officer is guilty of the crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the statement was made by the defendant, and 2, that the statement was made in response to a legitimate inquiry by a law enforcement officer, and 3, that the statement concerned a material fact about an offense within the officer's concern, and 4, that the defendant knew that such statement was false, and 5, that the statement was made by the defendant with the intent to obstruct or hinder the officer from apprehending or locating another person suspected of committing an offense. Law enforcement officer is defined as any officer, employee, or agent of government who has a duty imposed by law to maintain public order or make arrests for offenses, whether that duty extends to all offenses or is limited to specific offenses, and investigate the commission or suspected commission of offenses. Knowingly means that a person acts knowingly with respect to the conduct or to circumstances surrounding the conduct when the person is aware of the nature of the conduct or that the circumstances exist. A person acts knowingly with respect to the result of the person's conduct when the person is aware that the conduct is reasonably certain to cause the result. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Intentionally means that a person acts intentionally with respect to the nature of the conduct or to a result of the conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. If you find the defendant guilty of false report as charged in count 1 in the indictment, you shall so state and proceed to count 2. On the other hand, if you do not find that the state has proven beyond a reasonable doubt the guilt of the defendant, or if you have a reasonable doubt as to his guilt, then you shall find the defendant not guilty of count 1 and proceed to count 2. Count 2. As heretofore stated, in count 2 in the indictment, the defendant is charged with premeditated first-degree murder. Any person who commits the offense of first-degree murder is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant unlawfully killed the alleged victim, Sergeant Daniel Scott Baker, and 2, that the defendant acted intentionally. A person acts intentionally when it is the person's conscious objective or desire to cause the death of the alleged victim, and 3, that the killing was premeditated. A premeditated act is one done after the exercise of reflection and judgment. Premeditation means that the intent to kill must have been formed prior to the act itself. It is not necessary that the purpose to kill pre-exist in the mind of the accused for any definite period of time. The mental state of the accused at the time he allegedly decided to kill must be carefully considered in order to determine whether the accused was sufficiently free from excitement and passion as to be capable of premeditation. If the design to kill was formed with premeditation, it is immaterial that the accused may have been in a state of passion or excitement when the design was carried into effect. Excuse me. Furthermore, the premeditation can be found if the decision to kill is first formed during the heat of passion, but the accused commits the act after a passion has subsided. If you find from the proof beyond a reasonable doubt that the defendant is guilty of murder in the first degree, then it shall be your duty after a separate sentencing hearing to determine whether the defendant will be sentenced to death, life imprisonment without the possibility of parole, or life in prison, but you will not consider punishment for this offense at this time. If you find the defendant guilty of premeditated first-degree murder as charged in count 2 in the indictment, you shall so state and proceed to count 3. On the other hand, if you do not find the state has proven beyond a reasonable doubt the guilt of the defendant, or if you have a reasonable doubt as to his guilt, then you shall find the defendant not guilty of this offense and proceed to inquire as to whether or not the defendant is guilty of the lesser offense of second-degree murder. Any person who commits second-degree murder is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant unlawfully killed the alleged victim, Sergeant Daniel Scott Baker, and 2, that the defendant acted knowingly. Here, knowingly means that a person acts with an awareness that his conduct is reasonably certain to cause the death of the alleged victim. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Intentionally is defined in premeditated first-degree murder. If you find the defendant guilty of second-degree murder as a lesser-included offense of premeditated first-degree murder as charged in count 2 in the indictment, you shall so state and proceed to count 3. On the other hand, if you do not find that the state has proven beyond a reasonable doubt the guilt of the defendant, or if you have a reasonable doubt as to his guilt, then you shall find the defendant not guilty of count 2 and proceed to count 3. Count 3. As heretofore stated in count 3 in the indictment, the defendant is charged with first-degree murder in the perpetration of a felony crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant unlawfully killed the alleged victim, Sergeant Daniel Scott Baker, and 2, that the killing was committed in the perpetration or the attempt to perpetrate the alleged theft of property, the Ford Explorer police cruiser as alleged in count 4, that the killing was closely connected to the alleged theft of property and was not a separate, distinct, and an independent event, and 3, that the defendant intended to commit the alleged theft of property. Theft of property, as referred to here, is defined for you below in the instructions on count 4, and you should refer to those instructions here. The intent to commit the underlying felony theft must exist prior to or concurrent with the commission of the act causing the death of the victim. Proof that such intent to commit the underlying felony existed before or concurrent with the act of killing is a question of fact to be decided by the jury after consideration of all of the facts and circumstances. Consideration of such factors as time, place, and causation is helpful in determining whether a killing was committed in the perpetration of the alleged theft of property. The killing may precede, coincide with, or follow the theft of property and still be considered as occurring in the perpetration of the theft of property, so long as there is a connection in time, place, and continuity of action. Here, intentionally means that a person acts intentionally with respect to the nature of the conduct or to a result of the conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. If you find the defendant guilty of first-degree murder in the perpetration of a theft of property as charged in count 3, you shall so state and proceed to count 4. On the other hand, if you do not find the state has proven beyond a reasonable doubt the guilt of the defendant, or if you have a reasonable doubt as to his guilt, you shall find the defendant not guilty of this offense and proceed to inquire as to whether or not the defendant is guilty of the lesser included offense of second-degree murder. Second-degree murder was previously defined for you under count 2 above. Refer to the instructions previously provided here. If you find the defendant guilty of second-degree murder as a lesser included offense of first-degree murder in perpetration of a felony crime as charged in count 3 in the indictment, you shall so state and proceed to count 4. On the other hand, if you do not find the state has proven beyond a reasonable doubt the guilt of the defendant, or if you have a reasonable doubt as to his guilt, then you shall find the defendant not guilty of count 3 and proceed to count 4. As heretofore stated, in counts 4 and 5 in the indictment, the defendant is charged with theft of property. Any person who commits the offense of theft of property is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant knowingly obtained or exercised control over property. In count 4, alleged to be Sergeant Daniel Scott Baker's patrol vehicle number 500, a Ford Explorer police cruiser owned by the Dickson County Sheriff's Department. And in count 5, a Glock 17 handgun alleged to be possessed by Sergeant Daniel Baker as his service weapon, and Sergeant Daniel Baker's backup weapon, a Glock 33 handgun and ammunition owned by Sergeant Daniel Scott Baker. And 2, that the defendant did not have the owner's effective consent, and 3, that the defendant intended to deprive the owner of the property. Deprive means to withhold property from the owner permanently or for such a period of time as to substantially diminish the value or enjoyment of the property to the owner. Effective consent means assent in fact, whether express or apparent, including assent by one legally authorized to act for another. Exercise control over property is defined as the right to direct how property, real or personal, shall be used or disposed. Generally, one must possess the right of possession in property in order to exercise control over it. Anyone who is in a position to take some action that deprives the owner of property is in a position to exercise control. Obtain includes but is not limited to the taking, carrying away, or the sale, conveyance, or transfer of title to or interest in or possession of property. Owner means a person other than the defendant who has possession of or any interest in or any interest other than a mortgage, deed or trust or security interest in property, even though that possession or interest is unlawful and without consent, without whose consent, the defendant has no authority to exert control over the property. Property means anything of value, including but not limited to tangible or intangible personal property. Knowingly and intentionally have been defined under the definition of false report in count 1. Refer to those definitions here. If you find the defendant guilty of theft beyond a reasonable doubt, you must go further and fix the range of the value of the property. Value is the fair market value of the property at the time and place of the offense, or if the fair market value of the property cannot be ascertained, the cost of replacing the property within a reasonable time after the offense. If the property has value that cannot be ascertained by the criteria set forth in Part A above, the property is deemed to have a value of less than $50. The state has the burden of proving this value beyond a reasonable doubt as defined in these instructions. The jury will fix the value of the property or services obtained along with its verdict by indicating which of the following ranges the value falls within: $1,000 or less, more than $1,000 but less than $2,500, $2,500 or more but less than $10,000, $10,000 or more but less than $60,000. If you find the defendant guilty of theft of property as charged in count 4 in the indictment, you shall so state and proceed to count 5. On the other hand, if you do not find that the state has proven beyond a reasonable doubt the guilt of the defendant, or if you have a reasonable doubt as to his guilt, then you shall find the defendant not guilty of this offense and proceed to the lesser offense in count 4 of unauthorized use of a vehicle. Any person who commits the offense of unauthorized use of an automobile is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements: 1, that the defendant took another's automobile, and 2, that the taking was without the consent of the owner, and 3, that the defendant did not have the intent to deprive the owner thereof, and 4, that the defendant acted either intentionally, knowingly, or recklessly. Intentionally and knowingly have been defined for you in the instructions on false report in count 1. Refer to those definitions here. Recklessly means that a person acts recklessly with respect to circumstances surrounding the conduct or the result of the conduct when the person is aware of but consciously disregards a substantial and unjustifiable risk that the circumstances exist or that the result will occur. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all of the circumstances as viewed from the accused person's standpoint. Deprived and owner have been previously defined within the instructions on theft. Refer to those definitions again here. If you find the defendant guilty of unauthorized use of a vehicle, as in count 4 in the indictment, you shall so state and proceed to count 5. On the other hand, if you do not find that the state has proven beyond a reasonable doubt the guilt of the defendant, or if you have a reasonable doubt as to his guilt, then you shall find the defendant not guilty of count 4 and proceed to count 5. If you find the defendant guilty of theft of property as charged in count 5 in the indictment, you shall so state and proceed to count 6. On the other hand, if you do not find the state has proven beyond a reasonable doubt the guilt of the defendant, or if you have a reasonable doubt as to his guilt, then you shall find the defendant not guilty of count 5 and proceed to count 6. As heretofore stated, in count 6 in the indictment, the defendant is charged with criminal impersonation of a law enforcement officer. Any person who commits the offense of criminal impersonation is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements: 1, that the defendant pretended to be a law enforcement officer via a radio transmission from Sergeant Daniel Baker's patrol vehicle number 500 in response to a radio transmission from Dickson County Dispatch for the purpose of engaging in an activity that is ordinarily and customarily an activity established by law as a law enforcement activity. And 2, that the defendant did so for the purpose of causing another to believe that the person was a law enforcement officer. And 3, that the defendant acted either intentionally, knowingly, or recklessly. Law enforcement officer is defined in count 1. Knowingly and intentionally have been defined in count 1. Refer to those definitions here. Recklessly has been defined in counts 4 and 5. Refer to that definition here. If you find the defendant guilty of criminal impersonation of a law enforcement officer as law enforcement as charged in count 6 in the indictment, you shall so state and proceed to count 7. On the other hand, if you do not find the state has proven beyond a reasonable doubt the guilt of the defendant, or if you have a reasonable doubt as to his guilt, then you shall find the defendant not guilty of count 6 and proceed to count 7. As heretofore stated, in count 7 in the indictment, the defendant is charged with criminal impersonation of a law enforcement. Any person who commits the offense of criminal impersonation is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements: 1, that the defendant pretended to be a law enforcement officer via answering a cellular telephone call from Deputy Chris Lashley while using Sergeant Daniel Scott Baker's agency-issued cellular telephone for the purpose of engaging in an activity that is ordinarily and customarily an activity established by law as a law enforcement activity. And 2, that the defendant did so for the purpose of causing another to believe that the person was a law enforcement officer. And 3, that the defendant acted either intentionally, knowingly, or recklessly. Law enforcement officer is defined in count 1. Knowingly and refer to those definitions here. Recklessly is defined in count 4 and 5. Refer to that definition here. If you find the defendant guilty of criminal impersonation of law enforcement as charged in count 7 in the indictment, you shall so state and proceed to count 8. On the other hand, if you do not find that the state has proven beyond a reasonable doubt the guilt of the defendant, or if you have a reasonable doubt as to his guilt, then you shall find the defendant not guilty of count 7 and proceed to count 8. As heretofore stated, in count 8 in the indictment, the defendant is charged with tampering with evidence. Any person who tampers with evidence is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant knew an investigation or official proceeding was in progress. And 2, that the defendant destroyed or concealed a thing with the intent to impair its availability as evidence in the investigation or official proceeding by setting fire to Sergeant Daniel Scott Baker's patrol vehicle number 500 at Ford Explorer police cruiser. Conceal means to prevent disclosure or recognition by placing out of sight a thing. Destroy means to ruin the evidentiary value of a thing. Official proceeding means any type of administrative, executive, legislative, or judicial proceeding that may be conducted before a public servant authorized by law to take statements under oath. Thing means an object or an entity not precisely designated or capable of being designated. Knowingly and intentionally have been defined in count 1. Refer to those definitions here. If you find the defendant guilty of tampering with evidence as charged in count 8 in the indictment, you shall so state and proceed to count 9. On the other hand, if you do not find that the state has proven beyond a reasonable doubt the guilt of the defendant, or if you have a reasonable doubt as to his guilt, then you shall find the defendant not guilty of count 8 and proceed to count 9. As heretofore stated, in count 9 in the indictment, the defendant is charged with arson of personal property. Any person who commits the offense of setting fire to personal property or land is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant knowingly damaged personal property by fire or explosion, setting fire to Sergeant Daniel Scott Baker's patrol vehicle number 500, a Ford Explorer police cruiser. And 2, that the defendant did so with the intent to destroy or damage the said property for an unlawful purpose. Property has been defined for you in counts 4 and 5. Knowingly and intentionally have been defined in count 1. Refer to those definitions here. If you find the defendant guilty of arson as charged in count 9 in the indictment, you shall so state and proceed to count 10. On the other hand, if you do not find that the state has proven beyond a reasonable doubt the guilt of the defendant, or if you have a reasonable doubt as to his guilt, then you shall find the defendant not guilty of count 9 and proceed to count 10. As heretofore stated, in count 10 in the indictment, the defendant is charged with abuse of a corpse. Any person who commits the offense of abusing a corpse is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant did physically mistreat a corpse in a manner offensive to the sensibilities of an ordinary person by setting the corpse on fire. And 2, that the defendant acted without legal privilege. And 3, that the defendant acted knowingly. In deciding whether the act was offensive to the sensibilities of an ordinary person, the jury must avoid subjective, personal, and private views and evaluate the sensibilities of a hypothetical average adult person, applying the collective view of the adult community as a whole. Ordinary person means a person of ordinary care and diligence in relation to a particular thing. Legal privilege means a particular or peculiar benefit or advantage created by law. Knowingly and intentionally are defined in count 1. If you find the defendant guilty of abuse of a corpse as charged in count 10 in the indictment, you shall so state on your verdict form. On the other hand, if you do not find that the state has proven beyond a reasonable doubt the guilt of the defendant, or if you have a reasonable doubt as to his guilt, then you shall find the defendant not guilty of count 10. At times during the trial, I have ruled upon the admissibility of evidence. You must not concern yourself with these rulings. Neither by such rulings, these instructions, nor any other remarks which I have made do I mean to indicate any opinion as to the facts or as to what your verdict should be. As I previously instructed you, statements, arguments, and remarks of counsel are intended to help you in understanding the evidence and applying the law, but they are not evidence. If any statements were made that you believe are not supported by the evidence, you should disregard them. You are the exclusive judges of the facts in this case. Also, you are the exclusive judges of the law under the direction of the court. You should apply the law to the facts in deciding this case. You should consider all of the evidence in light of your own observations and experiences in life. The guilt of the defendant, as well as any fact required to be proved, may be established by direct evidence, by circumstantial evidence, or by both combined. Direct evidence is defined as evidence which proves the existence of a fact in issue without inference or presumption. Direct evidence may consist of testimony of a person who has perceived by the means of his or her senses the existence of a fact sought to be proved or disproved. Direct evidence is those parts of the testimony admitted in court which referred to what happened and was testified to by witnesses who saw, heard, or otherwise sensed what happened firsthand. If witnesses testify about what they themselves saw or heard or otherwise sensed, they presented direct evidence. Circumstantial evidence consists of proof of collateral facts and circumstances which do not directly prove the fact in issue, but from which that fact may be logically inferred. Circumstantial evidence is all of the testimony and exhibits which give you clues about what happened in an indirect way. It consists of all of the evidence which is not direct evidence. Do not assume that direct evidence is always better than circumstantial evidence. According to our laws, direct evidence is not necessarily better than circumstantial evidence. Either type of evidence can prove a fact if it is convincing enough. A defendant may be convicted on direct evidence, circumstantial evidence, or both. It is your duty to decide how much weight to give the direct and circumstantial evidence. The law makes no distinction between the weight you should give to either one, or say that one is any better evidence than the other. You should consider all of the evidence, both direct and circumstantial, and give it whatever weight you believe it deserves. During the trial, you heard a number of expert witnesses. The rules of evidence provide that if scientific, technical, or other specialized knowledge may assist the jury in understanding the evidence or in determining a fact and issue, a witness qualified as an expert by reason of special knowledge, skill, or experience may testify and state her or his opinions concerning such matters and give reasons for her or his testimony. Merely because an expert witness has expressed an opinion does not mean, however, that you are bound to accept this opinion. The same as with any other witness. It is up to you to decide whether you believe this testimony and choose to rely upon it. Part of that decision will depend on your judgment about whether the witness's background or training and experience is sufficient for the witness to give the expert opinion that you heard. You must also decide whether the witness's opinions were based on sound reasons, judgment, and information. You are to give the testimony of expert witness such weight and value as you think it deserves, along with all of the other evidence in the case. You are the exclusive judges of the credibility of the witnesses and the weight to be given to their testimony. If there are conflicts in the testimony of different witnesses, you must reconcile them, if you can, without hastily or rashly concluding that any witness has sworn falsely. For the law presumes that all witnesses are truthful. In forming your opinion as to the credibility of a witness, you may look to the proof, if any, of his or her general character, the evidence, if any, of the witness's reputation for truth and veracity, the intelligence and respectability of the witness, his or her interest or lack of interest in the outcome of the trial, his or her feelings, his or her apparent fairness or bias, his or her means of knowledge, the reasonableness of his or her statements, his or her appearance and demeanor while testifying, his or her contradictory statements as to material facts, if any, are shown, and all the evidence in the case tending to corroborate or to contradict him or her. The defendant has not taken the stand to testify as a witness, but you shall place no significance on this fact. The defendant is presumed innocent, and the burden is on the state to prove his guilt beyond a reasonable doubt. He is not required to take the stand in his own behalf, and his election not to do so cannot be considered for any purpose against him, nor can any inference be drawn from such fact. The court charges you that the identity of the defendant must be proven in the case on the part of the state to your satisfaction beyond a reasonable doubt. In other words, the burden of proof is on the state to show that the defendant, now on trial before you, is the identical person who committed the alleged crime with which he is charged. In considering the identity of a person, the jury may take into consideration all of the facts and circumstances of the case. The court further charges you that if you are satisfied from the whole proof in the case beyond a reasonable doubt that the defendant, Stephen Joshua Wiggins, committed a crime charged against him, and you are satisfied beyond a reasonable doubt that he has been identified as the person who committed the crime charged, then it would be your duty to convict him. On the other hand, if you are not satisfied with the identity from the proof, or if you have a reasonable doubt as to whether he has been identified from the whole body of the proof in the case, then you should return a verdict of not guilty. Evidence of a confession has been introduced in this case. A confession is a statement by the defendant that he engaged in conduct which constitutes the crime charged and is acknowledgement of guilt itself. The court has ruled that the confession is admissible in evidence, but it is your duty to judge its truth. In so judging, you should consider the circumstances under which the confession was obtained, as well as any evidence which contradicts all or part of the statements made. You must consider all of the statements made by the defendant, whether favorable or unfavorable to him, and you must not disregard any of them without good reason. If the evidence in the case leads you to believe that the confession or any part of it is untrue or was never made, you should disregard it or that portion which you do not believe. You are the sole judge of what weight you should be given to those portions of the confession which you believe, and you should consider them along with all of the other evidence in the case in determining the defendant's guilt or innocence. If from the proof you find the defendant has committed a crime other than that for which he is on trial, you may not consider such evidence to prove his disposition to commit such a crime as that on trial. This evidence may only be considered by you for the limited purpose of determining whether it provides a complete story of the crime, that is, such evidence may be considered by you where the prior crime and the present alleged crime are logically related or connected, or are part of the same transaction, so that the proof of the other tends or is necessary to prove the one charged, or is necessary for a complete account thereof. Or motive, that is, such evidence may be considered by you if it tends to show a motive of the defendant for the commission of the offense presently charged. Such evidence of crime, if considered by you for any purpose, must not be considered for any purpose other than that specifically stated. Fingerprint evidence has been presented in this case. You may consider this evidence in determining the defendant's identity as the person who committed the crime. Fingerprint evidence is circumstantial evidence. That is, it is proof of collateral facts and circumstances from which the existence of a primary fact may be deduced by you according to reason and common experience. There are no two sets of fingerprints exactly alike. For fingerprint evidence alone to sustain a conviction, you must find that the defendant's fingerprints could only have been impressed at the crime scene during the commission of the crime. The weight to be accorded fingerprint evidence is a question for the jury to decide in light of all of the surrounding facts and circumstances of the case. The flight of a person accused of a crime is a circumstance which, when considered with all of the facts of the case, may justify an inference of guilt. Flight is the voluntary withdrawal of oneself for the purpose of evading arrest or prosecution for the crime charged, whether the evidence presented proves beyond a reasonable doubt that the defendant fled is a question for your determination. The law makes no precise distinction as to the manner or method of flight. It may be open, or it may be a hurried or concealed departure, or it may be a concealment within the jurisdiction. However, it takes both a leaving the scene of the difficulty and a subsequent hiding out, evasion, or concealment in the community, or a leaving of the community for parts unknown to constitute flight. If flight is proved, the fact of flight alone does not allow you to find that the defendant is guilty of the crime alleged. However, since flight by a defendant may be caused by a consciousness of guilt, you may consider the fact of flight, if flight is so proven, together with all of the other evidence when you decide the guilt or innocence of the defendant. On the other hand, the entirely innocent person may take flight, and such flight may be explained by proof offered or by the facts and circumstances of the case. Whether there was a flight by the defendant, the reasons for it, and the weight to be given to it are questions for you to determine. If you find beyond a reasonable doubt from the evidence that the property in question has been recently stolen, and that soon thereafter the same property was discovered in the exclusive possession of the defendant, this possession, unless satisfactorily explained, is ordinarily a circumstance from which you may reasonably draw an inference that the defendant gained possession through theft. However, you are never required to make this inference. It is for you to determine whether the facts and circumstances shown by the evidence in this case warrant any inference in which the law permits you to draw from the possession of recently stolen property. When the evidence is offered that the defendant was in possession of recently stolen property, the defendant has the right to introduce evidence that he came into possession of the property lawfully, or possession may be satisfactorily explained through other circumstances or other evidence, independent of any evidence offered by the defendant. In considering whether possession of recently stolen property has been satisfactorily explained, you're reminded that in the exercise of constitutional rights, the accused need not take the witness stand and testify. The term recently is a relative term, and it has no fixed meaning. Whether property may be considered as recently stolen depends upon the nature of the property and all of the facts and circumstances shown by the evidence in the case. The longer the period of time since the theft, the more doubtful becomes the inference that which may be drawn from unexplained possession. The correctness of the inference and the weight to be given by any explanation that may be shown by the evidence are matters that must be determined by you, and you are not bound to accept either. You must weigh all of the evidence presented as to the defendant's alleged possession of the property in question and decide in light of all the facts and circumstances present whether that any inference is warranted. You are reminded that the burden of proving the defendant's guilt of the offense beyond a reasonable doubt remains on the state. A stipulation is an agreement. The parties have stipulated that certain matters of fact are true, and this stipulation has been entered as an exhibit. They are bound by this agreement, and in your consideration of the evidence, you are to treat these facts as proven. The verdict must represent the considered judgment of each juror. In order to return a verdict, it is necessary that each juror agree thereto. Your verdict must be unanimous. It is your duty as jurors to consult with one another and to deliberate with a view to reaching an agreement if you can do so without violence to individual judgment. Each of you must decide the case for yourself, but do so only after an impartial consideration of the evidence with your fellow jurors. In the course of your deliberations, do not hesitate to re-examine your own views and change your opinions if convinced it is erroneous. But do not surrender your honest conviction as to the opinion of your fellow jurors or for the mere purpose of returning a verdict. You can have no prejudice or sympathy or allow anything but the law and the evidence to have any influence upon your verdict. You must render your verdict with absolute fairness and impartiality as you think justice and truth dictate. If after your deliberations you find the defendant guilty of any offense other than first-degree murder, the court will set the punishment at a separate sentencing hearing. The jury will not be involved in setting the punishment for offenses other than first-degree murder. When you retire to the jury room, you will first select one of your members as foreman or forelady who will preside over your deliberations. When you have reached a verdict, you will return with it to this courtroom, and your foreman or forelady will deliver the appropriate verdict forms to the court. In reaching your verdict, you must consider the offense charged in each count in the indictment. If you unanimously find the defendant guilty of that offense beyond a reasonable doubt, then you shall return the verdict of guilty for that offense as to the defendant. If you unanimously find the defendant not guilty of that offense or have a reasonable doubt of the defendant's guilt of that offense, you shall find the defendant not guilty, and you shall then proceed to consider whether or not the defendant is guilty of the next lesser included offense in order from greatest to least, if a lesser included offense is included. You shall not proceed to consider any lesser included offense until you have first made a unanimous determination that the defendant is not guilty of the immediately preceding greater offense, or if you unanimously have a reasonable doubt of the defendant's guilt of that offense. If you have a reasonable doubt of the guilt of the defendant as to all offenses charged and included in each count in the indictment, you shall return a verdict of not guilty as to that count. As I previously instructed you, you may not view any media or communicate with anyone concerning this case. During your deliberations, you must not communicate with or provide any information to anyone by any means about this case outside of the jury deliberation room. The crime charged in each count in the indictment is a separate and distinct offense. You must decide each charge separately on the law and evidence applicable to it. The defendant may be found guilty or not guilty of any and all offenses charged. Your findings as to each crime charged must be stated in your verdicts. If you find the state has proven the defendant guilty beyond a reasonable doubt, then you should find him guilty. On the other hand, if you find that the state has not proven beyond a reasonable doubt the defendant's guilt, or if you have a reasonable doubt as to his guilt, then you must find him not guilty. You will be provided with forms for the verdicts in each count in this case. The jury will complete the verdict form for each count, and your foreperson will sign each verdict form. The verdict forms that you have been provided, let me locate my copies. This is the verdict form that you're being given, and they will read as follows. The verdict form for count 1, false report. We, the jury, find the defendant Stephen Joshua Wiggins, and then you only check one, A, guilty of false report, or B, not guilty. And it goes through each count. Verdict form, count 2, premeditated first-degree murder of Sergeant Daniel Scott Baker. We, the jury, find the defendant Stephen Joshua Wiggins. Check only one, A, guilty of premeditated first-degree murder of Sergeant Daniel Scott Baker, or B, guilty of second-degree murder of Sergeant Daniel Scott Baker, or C, not guilty. In verdict for count 3, first-degree felony murder, we, the jury, find the defendant Stephen Joshua Wiggins. Check only one, A, guilty of first-degree felony murder of Sergeant Daniel Scott Baker during the perpetration of or attempt to perpetrate theft, or B, guilty of second-degree murder of Sergeant Daniel Scott Baker, or C, not guilty. Count 4, theft of property, the Ford Explorer. We find the defendant Stephen Joshua Wiggins guilty of theft, that's A, or B, guilty of unauthorized use of a vehicle, or C, not guilty. For count 5, theft of property, we, the jury, find the defendant Stephen Joshua Wiggins A, guilty of theft, or B, not guilty. Count 6, criminal impersonation, we, the jury, find the defendant Stephen Joshua Wiggins A, guilty of criminal impersonation, or B, not guilty. For count 7, criminal impersonation, we find the defendant Stephen Joshua Wiggins A, guilty of criminal impersonation, or B, not guilty. Count 8, tampering with evidence, we, the jury, found the defendant Stephen Joshua Wiggins A, guilty of tampering with evidence, or B, not guilty. Count 9, arson, we, the jury, found the defendant Stephen Joshua Wiggins A, guilty of arson, or B, not guilty. And count 10, abuse of a corpse, we find the defendant Stephen Joshua Wiggins A, guilty of abuse of a corpse, or not guilty. I need one more additional charge. Do you have the TPI? Counsel, approach the bench, please. There is a reference to an inference on a flight to the word inference, so it's recommended that we charge the definition under 42.19 of inference. So I'm just going to read that from the TPI, and we'll print it out and send it back with us. All right, thank you. Ladies and gentlemen, it was decided I have not read enough to you, so we're going to add one more additional charge that will help you to understand one particular aspect of this charge. Ladies and gentlemen, I'm going to read this charge to you from Tennessee pattern jury instructions, and then it will be printed and sent back with the original charge. So this will just be an additional charge to you. The court has charged you concerning an inference that the jury may make in regard to certain evidence in this case. However, the jury is not required to make this inference. It is the exclusive province of the jury to determine whether the facts and circumstances shown by all of the evidence in the case warrant the inference which the law permits the jury to draw. The inference may be rebutted by direct or circumstantial evidence, or both, whether it exists in the evidence or the state or is of the state or is offered by the defendant. Although the defendant is not required by law to do so, when the defendant offers an explanation to rebut the inference raised, you should consider such explanation along with all of the evidence to determine not only the correctness of the inference, but also the reasonableness of the defendant's explanation. You're not bound to accept either the inference or the defendant's explanation. The state must also prove beyond a reasonable doubt every element of the offense before the defendant can be found guilty. And that was regarding the language that was used in our charge regarding an inference regarding flight, if you remember that terminology. So we will print that up and add it to it. Now, you're reminded that you're required to report a verdict or failure to agree on every count of the indictment. And at this point, I will then randomly select the jurors who will be serving as alternates. Now, when I select these names, you will need to allow the clerk to, you will need to stay where you are, and then we will, I think you've all been given your numbers, correct? So as I read these numbers out, you'll need to keep your seat when the other 12 go forward into the jury room to begin deliberation. Number 52. Number 46. Number 59, and number 27. If you know your numbers, those 12 that whose numbers were not called, if you will now go with our bailiff to begin your deliberations. Hold on just a second, please.
Do any of those four have something in the jury room they need to get out?
Well, if you have, any of the four of you whose numbers have been called have matters in the jury room or property in the jury room, I'll explain to you how we're going to handle you from here on out, but if you'll remain seated, we'll make sure that your items are brought out by one of the bailiffs. So the other 12 whose numbers were not called may now retire to begin deliberation. All right. Let me explain to you that it's not as simple as that you're going to be the alternate, you get to pack up and go home. Because of the fact that we have to wait and see what the jury that is deciding the case decides regarding the offenses that have been charged, if we go to a sentencing on a capital case, then we're going to need to have you remain so that we can have a possibility of using you if something happens during the sentencing phase. Once they have arrived at a verdict, then we will bring everybody back in, have that verdict announced. In the meantime, you have to be kept separate. You can be together, but you'll be kept separately in another courtroom, and you'll be transported separately, you'll be kept separately until we determine whether or not you're going to be necessary to fill in for someone who's on the 12. Now, the difficult part is going to be that you are not allowed to discuss this case among yourselves or let anyone else discuss it with you until the final determination whether you're going to be needed for sentencing and so forth. So you will be brought in from the separate place that you're being kept, And you'll be seated in front of the jury box during the sentencing phase if we get to that phase, and you'll be listening to all of that evidence the same as the other 12 will be. The point of that exercise is that if something were to happen, God forbid, to one of those 12 or their family or something, that they had to be relieved, one of you would then randomly be chosen to fill in and take their spot. And you will need to have listened attentively to all of the evidence, and you will have the same opportunity at sentencing then as they would have. So I realize that's a difficult proposition. I realize it's an inconvenient one, but you'll get the same type of care you're getting. You're just going to be kept separate from everyone else. So the bailiffs are going to arrange for you to get your items when we're going to take a recess pending the return of the jury's verdict. But right now, what I need is you to let Officer Howell know if there's anything in the jury room you need to retrieve. You will then be moved to courtroom number 6 down the hallway here, and it'll be it's a courtroom identical to this. It'll be locked to the public, and you'll have the opportunity for anything you need to do. And is there anything else, Ms. Jones?
They just need to understand that from this point forward, they can't talk with any of the twelve.
Okay. As I explained to you, you're not to discuss this case with any other person, but you need to also understand that you are not to discuss this case or talk to any of those 12 people. We are isolating you from everyone except the 4 of you, and you can't talk about the case. So that's the important part. All of this there's reasons and logical reasons that may not be readily apparent to you, but it is also for trying to protect the integrity of this situation and have a backup plan in case there is one. I know it's inconvenient. I appreciate your patience in dealing with all of this, but if you will let Officer Howell, when we take our recess, let him know what you need. Here is the original charge and the jury verdict form. Anything then before we take a recess? All right. Let's make sure that,
Everything can go back.
you want to go back
besides-
out there and make sure that they don't do anything they're supposed to not do.
Everything can go back besides the DVDs and the weapons.
Question is if the jury requests, the exhibits normally would go back with the exception of weapons and any sort of audio-visual material they'd have to come in here to look at.
That and those exhibits that were entered for ID only under the active transcript.
Right. If there were exhibits that were identification only or tendered as a effort to preserve the record, I think, then why don't we do this? Let's have a representative of the defense and the state come forward when I recess and make sure what's going to be going back to the jury, that there's an agreement.
Yeah, and I have one issue to raise.
That's fine.
Please. If I understood, Your Honor was going to maintain the alternates pending the deliberation. Obviously, the defense would lodge an objection to the alternates being preserved for that purpose. Rule 24 F. 2A and B. Jury is not selected to be a member of the deliberating jury shall be discharged when that jury retires to consider its verdict. It's a shall. It's under the F2A. You are also under the, I think it's Steve versus Bobo. When I quote, any alternate not replacing a regular juror shall be discharged when the jury retires to consider its verdict, unquote. So in this instance, the jury has retired to consider its verdict. I don't think it's appropriate or proper. I don't think the rules allow for it. I think it says shall be discharged. I think the alternates have to be discharged.
All right, there's a case that's been presented to me that was the basis for my taking that position, so I'm going to look at that case, and then I'll come back in a few months. We'll take a short recess, and then I'll come back in and advise you of my ruling on that issue. All right. We'll be in recess until I can determine that issue.